Welcome back to the Deep Dive. It is Thursday, January 22nd, 2026. And look, I have to be honest with you, today's stack of sources is, it's a heavy one. Usually we like to start with something a bit more abstract, maybe a big geopolitical shift or a new tech trend. But today we are zooming in on a very specific room, a courtroom. It's in Tacloban City in the Philippines. And then we're going to have to zoom way out to the halls of the United Nations in Geneva to really understand why that one room matters so much.
It is a heavy day and historic one, frankly, though I would argue for all the wrong reasons.
So let's set the scene. This is happening today, right now, really. Breaking news. A verdict has just been handed down that legal analysts, human rights watchdogs, they're all calling it a global first.
Yeah.
Talking about Frenchie Mae Cumpio.
Yes.
She's a journalist, 27 years old. Well, actually, wait. Looking at the timeline here, she turns 27 tomorrow, right?
That's right. Her birthday's tomorrow, January 23rd. The timing is just brutal.
So on the literal eve of her 27th birthday, she has just become the first journalist in the world convicted of terrorism financing.
It's a landmark case in the worst possible way. She and her colleague, a humanitarian worker named Mariel Domicul, were just sentenced to between 12 and 18 years in prison.
12 to 18 years.
And to really understand the weight of this, you have to get into the details our sources provided about the scene outside that courtroom. It's
Right.
very human.
Plus?
Frenchie's mother, Roxy, was there, and she had packed a bag.
Like a go bag for prison.
No, the opposite, a going home bag. She'd packed fresh clothes. She was convinced, or at least she was praying, that her daughter would be acquitted and would be walking out a free woman today.
Oh, wow.
And she even brought a meal from Jollibee, fried chicken. It was meant to be a celebration.
A birthday celebration.
A birthday and a freedom celebration, although, and this detail just breaks your heart, the guards apparently prohibited the gravy.
They didn't allow the gravy.
No,
Yeah.
some sort of security protocol. But, this small detail, it's just so emblematic of the cruelty of it all. She brought this meal with so much hope.
And instead?
Instead, the verdict was read, the sentence was passed, and the family left the courthouse in tears.
That detail about the gravy, so small, but it grounds this huge legal precedent in such a human, painful moment. It's just a chicken without the sauce, but it represents this total loss of normalcy, of hope.
Exactly.
But look, we aren't just here to talk about one tragedy in the Philippines, as awful as it is. We are here because this verdict is, and I'm quoting from the documents we've analyzed here, the tip of the iceberg.
It really is. It's the tip of the iceberg of a much larger systemic crisis that's facing the United Nations.
And that's the real mission of this deep dive. We need to talk about reprisals.
Reprisal.
It's a word we hear in war movies,
Yeah.
What does it actually mean in this context?
In the context of the UN human rights system, a reprisal is very specifically an act of intimidation or retaliation against individuals or groups who cooperate or even just try to cooperate with the United Nations.
So if you talk to the UN, you become a target.
That's the heart of it. We're analyzing a really comprehensive report from the International Service for Human Rights, or ISHR, and we're stacking that alongside legal analysis of this Cumpio verdict. And the core question is just, what happens when the very people who report human rights abuses, the UN's eyes and ears on the ground, become targets themselves?
And not just targets of, thugs on the street, but targets of the law itself. I've seen it called lawfare.
That is the perfect term for it. And we're going to unpack exactly how nations are weaponizing their own laws, counterterrorism laws, financing laws, to silence dissenters before they can even think about sending an email to Geneva.
And then we have to turn the mirror back on the UN system itself because, the sources seem to suggest it's struggling, that in some cases it's actually failing to protect the very people who talk to it.
It's a huge challenge for the entire system, a foundational one.
Okay, let's start there with the story that's breaking right now. Section 1. The case of Frenchie Mae Cumpio. Who is she? Because I have to admit, before today, I hadn't seen her name in the major Western headlines.
No, and that's part of the story. She wasn't a global celebrity, but she was an absolute pillar in her local community. Frenchie Mae Cumpio was the executive director of a local news outlet called Eastern Vista. She was also a radio anchor at XCN Radio Tacloban.
And she was young when this all started.
Incredibly young, only 21 when she was arrested. And she was known for covering the stories that often get ignored, the struggles of local farmers, marginalized groups, and very specifically, alleged abuses by the police and military in the eastern Visayas region of the Philippines.
Right. And I have to imagine that reporting on police and military abuses in that part of the world That puts a target on your back.
A massive one. And in the Philippines, there's a specific context we have to explain. It's a tactic called red tagging.
Red tagging, is that, what is that? Like being put on a blacklist?
It's more aggressive than that. It's much more dangerous. It's the practice of government officials or military bodies publicly labeling critics, journalists, activists, lawyers, anyone really, as communists or terrorists, often with absolutely zero proof.
It's just an accusation.
It's an accusation that functions as a threat. In the Philippines, being red tagged is widely seen as a prelude to being physically attacked or arrested. It's like painting a bullseye on someone's forehead.
And there's a specific government body behind this. I saw an acronym in the notes.
Yes, the NTF-ELCC.
That is quite the mouthful.
It stands for the National Task Force to End Local Communist Armed Conflict. And they've been very active in labeling all sorts of organizations as fronts for the New People's Army, or NPA, which is the armed wing of the Communist Party of the Philippines.
So Frenchie was red tagged before any of this happened.
Oh, yes. She was already in the crosshairs. She knew she was a target.
So let's go back to the arrest itself. This didn't just happen today. She's been in jail for a while now.
For a long time, nearly 6 years. She was arrested on February 7, 2020. It was a raid on what was essentially her staff house in Tacloban. This was part of a larger series of arrests that became known as the Tacloban Five.
And the initial charges were what?
Originally, the headline charges were illegal possession of firearms and explosives. Authorities claim they found a pistol and a grenade in the house during the raid.
Which, I mean, it feels like a classic narrative in these types of raids, doesn't it? We raided the journalist's house, and what do you know? A grenade just happened to be under the pillow.
It is a very, very common pattern in the region and elsewhere. Cumpio and her defense team have, of course, always maintained that those weapons were planted.
Okay, but here's the part about today's verdict that's so strange.
Yes.
The court actually acquitted them on the firearms charge.
That's right. It's a crucial detail. The court looked at the evidence and essentially said, "We don't think you had the guns." The prosecution failed to prove beyond a reasonable doubt that the firearms were theirs.
So, they went on that count.
They went on that count. But, and this is the massive pivot, the legal sleight of hand, they were convicted on this other charge of terrorism financing under something called Republic Act number 1168.
Okay, I want to pause here because this seems incredibly specific and strategic. Why terrorism financing? Why not just charge her with sedition or libel if the goal was just to silence her?
That is the key question, and it gets to the heart of modern authoritarian tactics. This is lawfare at its most sophisticated. If you charge a journalist with sedition, they become a political martyr. It looks like a free speech issue. It rallies international support.
Right, it's obvious what's happening.
But if you charge them with terrorism financing, two things happen immediately. First, it completely stigmatizes them. It labels them as a danger to society, which scares away their allies and supporters.
I can't support a terrorist. It poisons the well.
Exactly. And second, and this is crucial from a tactical perspective, it triggers automatic financial mechanisms. It gives the state the power to freeze bank accounts, not just of the individual, but of the entire organization. It suffocates the news outlet.
You cut off the oxygen.
You do. The ISHR report identifies this as a dragnet strategy. These statutes, which were originally designed to stop, Al-Qaeda or ISIS, are now being used to stop a local reporter from buying lunch for a source.
So what was the financing in this case? What was the specific allegation? Were you talking about millions of dollars?
Not even close. The allegation from the prosecution was that Cumpio and Domaquil provided funds to the New People's Army. Specifically, the court cited a transfer of P100,000.
P100,000. In U.S. dollars, that's got
roughly $1,800.
$1,800. That's the basis for an 18-year prison sentence for terrorism financing.
That's the amount. The prosecution claimed this money, along with some ammunition, was delivered to the NPA in a nearby city. Now, the timeline is, let's just say it's messy. The prosecution alleged the support happened in 2021.
But wait, you said she was arrested in February 2020, so she was in jail in 2021. How could she be delivering money?
That is one of the major glaring contentions from the defense. But the specific evidence, the money that was found during the raid, that's where this story gets incredibly contradictory. And this is really the aha moment for anyone analyzing the legal documents.
Right. I saw this in our notes. There's a major twist involving a higher court.
A huge twist. Just a few months ago, in October of 2025, the Philippine Court of Appeals, which is a higher court than the one that convicted her today, issued a ruling. And it was about the civil forfeiture of these exact same funds.
Okay, hold on. Let me make sure I'm getting this straight. The government tried to seize the money found in the raid. saying it was dirty money, right?
Correct.
And the Court of Appeals looked at that specific case.
Yes. The Anti-Money Laundering Council, the AMLC, had frozen her accounts and tried to seize the P100,000, claiming it was for terrorism. But the Court of Appeals completely reversed that. They ruled there was no legal basis for the forfeiture.
So the higher court looked at the evidence and said, this isn't terror money.
They went much, much further than that. I actually want to read you a quote from that Court of Appeals decision because it is scathing.
Please.
They said the court, quote, cannot countenance the hasty labeling of human rights advocates as terrorists. To permit the forfeiture would be tantamount to committing the evil which the Anti-Terrorism Act sought to avoid.
Wow. That is a direct rebuke. They're basically saying, you are using the anti-terror law to terrorize activists. That's what that says.
Precisely. The defense had argued all along that the money was for a humanitarian campaign. It was called Stand with Samar Light, and it was to help local farmers. The Court of Appeals seems to have accepted that there was no provable link to terror.
So, just to be crystal clear, the higher Court of Appeals says, this is not terror money. But today, a lower trial court says, yes, it is, and you're going to jail for up to 18 years for it. Yeah. How is that even legally possible?
It creates a legal paradox. It's a mess. But you have to understand, in a weaponized legal system, confusion and contradiction are often part of the punishment. It's designed to exhaust and demoralize you. And for Frenchie Mae Cumpio, that paradox means she is spending her 27th birthday in a cell.
And the reaction from the international community has been swift. I saw UN Special Rapporteur Irene Khan, who actually visited Cumpio in jail back in 2024. She immediately called these charges retaliation for her journalism.
And that word retaliation, that's the bridge. Yeah. That bridges us from this one courtroom to the broader theme of our deep dive. Because what happened in Tacloban today is a perfect, tragic, textbook example of a global trend.
The weaponization of the law.
The weaponization of national security laws against anyone who cooperates with the UN or even just tries to hold power accountable domestically.
Yeah.
It sends a message, doesn't it?
It sends a chilling message, it says. If you report on us, we won't just arrest you. We will brand you a terrorist. We will freeze your life, your funds, your reputation, and then we will lock you away for decades.
And this is what brings us to the United Nations. Because theoretically, the UN is the place where people like Frenchie Mae Cumpio are supposed to be able to turn when their own governments fail them.
Theoretically. But as we're about to see, that whole system is under siege.
It really is.
Let's move to Section 2, the UN system under siege. We define reprisals. It's intimidation for cooperating with the UN. Now, there has to be a rule against this. The UN must have a rule.
They do. It's a cornerstone of the system. It's Human Rights Council Resolution 3621.
Resolution 3621. Okay, it sounds like just another number in a sea of UN documents. Why does this one matter so much?
It matters because it's the foundational promise. It's the UN looking at the world and saying, everyone has the right to unhindered access to us. It explicitly states that no one should suffer any kind of retaliation for speaking to the Human Rights Council or a treaty body or any UN mechanism.
And it puts the responsibility on the countries themselves.
Yes, it places the primary duty on states to protect that right.
But isn't that the fundamental problem? You're asking the state to protect the person who is complaining about the state. I mean, it's like asking the fox to guard the hen house.
That is the structural flaw in the whole system. You've hit it exactly. So when the state fails, or more often, when the state is the perpetrator, the UN has mechanisms to step in.
And there's an actual person whose job this is.
Right. There is. There's a senior official on reprisals.
That sounds like a tough job. Who is it?
Currently, it is the Assistant Secretary General for Human Rights, Ilse Brands-Keris. Her mandate is to lead the entire UN effort to stop this kind of intimidation.
How does she do that? Does she fly to countries and demand people be released? Does she hold press conferences and name and shame?
Well, that's a major point of contention in our sources. The current approach under her leadership is heavily focused on what they call private representations.
It's quiet diplomacy.
Exactly. It's code for asking nicely behind closed doors.
So sending letters, having private meetings with ambassadors.
Yes, saying, hey, we are concerned about this case. Can you please fix it? The argument in favor of this is that it can sometimes de-escalate a situation without causing a public international incident. But the ISHR report is, well, it's quite critical here.
How so?
It notes that the previous senior official, a man named Andrew Gilmore, was much more willing to go public. He spoke out openly about specific cases in Egypt and Bahrain. He named names.
And the critique is that quiet just isn't working.
The critique is this. When the reprisals are loud, like a very public 18-year conviction of a journalist in Tacloban, can the response effectively be quiet?
It's a good question.
If you stay quiet, the state often assumes they got away with it. The silence can be interpreted as permission.
So if the quiet diplomacy fails, what's next? Is there a public forum?
Yes. That same resolution, 3621, established something called the Interactive Dialogue on Reprisals.
An interactive dialogue. That sounds a little like corporate speak for a meeting that could have been an email. What actually happens in that room?
Chuckles. It's supposed to be the moment of accountability. It's a big debate at the Human Rights Council. Imagine this massive hall in Geneva. The UN Secretary General submits his annual report, and it lists all the countries accused of reprisals. Here are the states that attacked activists this year.
And the idea is peer pressure. Other countries are supposed to stand up and call them out.
That's the idea. Naming and shaming, peer pressure. But in practice, the sources say it's mostly theater.
How so?
Well, when a country like Egypt or China or Russia gets named in that report, they don't apologize. They take the microphone and they attack the report itself. They call it biased, they call it Western propaganda, they deny the facts entirely.
So instead of peer pressure, you just get a diplomatic shouting match.
Or worse, you get silence. The ISHR report notes that most other states just sit on their hands. Very few are willing to stand up and raise specific cases. Germany is mentioned as a positive exception. They consistently raise the case of an Egyptian lawyer named Ibrahim Metwali who was detained.
But mostly, it's crickets.
Mostly, you have the perpetrators dominating the floor to deny everything, and the victims and their families are left without a champion in the room. It can be a very disheartening process.
That is depressing. The report also mentions something called the San Jose Guidelines. What are those?
Those were created back in 2015. It's basically a rule book, a set of guidelines for the UN treaty bodies.
The treaty bodies. Those are the specialized committees that monitor things like the Convention Against Torture or the Rights of the Child, right?
Exactly. And the guidelines tell these expert committees, if someone talks to you and then gets arrested, here is exactly what you need to do. It's meant to standardize the response, make it swift and predictable.
But is it working?
The problem is, adoption has been inconsistent. For example, the report notes that the Committee on Economic, Social, and Cultural Rights, a major body, still hadn't formally endorsed them. So there are gaps. And then there's another layer of difficulty the sources mention, the legacy of the pandemic.
The pandemic. How does COVID fit into all this?
When everything went virtual, the UN actually reported fewer reprisals.
Oh, because everyone was being nicer to each other during lockdown.
Not quite. It's because it is much, much harder to report a reprisal safely online if you live in a surveillance state.
Ah, of course.
If you have to zoom into a UN meeting from your apartment in a country with heavy internet monitoring, you might just choose not to show up. Or if you do, and something happens, you can't just slip a note to a UN officer in the hallway. The digital gap created a massive safety gap.
That makes total sense. If the channel itself isn't secure, you don't use it. You can't.
And that actually leads us to a truly terrifying escalation. We've talked about attacks on journalists and activists, but Section 3 of our deep dive covers something that crosses a very bright red line, attacks on the UN officials themselves.
Yeah, this part of the source material really shocked me. I think I had this naive assumption that if you are a UN-appointed expert, a special rapporteur, you have some sort of diplomatic immunity shield. You're untouchable.
You are supposed to be. Your independence and safety are meant to be sacrosanct. But the sources describe a copycat phenomenon. States are seeing that they can get away with attacking local activists, so now they're getting bolder. They're emboldened to go after the international experts. They are pesting the fence to see if it's electrified.
Let's talk about the case study here. Anexa Alfred Cunningham. This story is just wild.
It is a stark, unambiguous example of a state going rogue against the UN system. Anexa Alfred Cunningham is an expert on indigenous law. She's from Nicaragua, and she was appointed as a member of the UN Expert Mechanism on the Rights of Indigenous Peoples, or EMRP. It's a very high-level role.
So she's a UN expert, but she's also a Nicaraguan citizen.
Correct. So in July of 2022, she travels to Geneva for her official mission. She does her work with the UN. Then she tries to fly home, back to Nicaragua.
Yeah.
The government denied her entry.
They locked their own citizen out of the country for doing her job with the UN.
Essentially exiled her, banishment, simply because she served the UN as an independent expert. The president of the UN Human Rights Council tried to intervene, sent messages, tried to get an explanation, and the Nicaraguan government just ghosted them Complete silence. No response.
That is mind-blowing. A member state of the United Nations is banishing a UN expert who is one of their own citizens. It's like they're saying, your UN badge means absolutely nothing here. Your mandate is irrelevant.
And it's not an isolated incident. Look at the case of Agnes Callamard. She was the special rapporteur investigating the murder of the journalist Jamal Khashoggi.
The journalist killed in the Saudi consulate in Istanbul.
Yes. The sources note that a senior Saudi official issued a direct death threat against her. A direct threat from a state official against a UN investigator for doing her job.
Unbelievable. And then there's the example from China involving Wu Hongbo. This one really highlights the conflict of interest that can exist right inside the UN building.
Wu Hongbo was a former UN Undersecretary General, so a very, very high-ranking official within the UN's own structure. But in a televised interview, he basically admitted that he ordered the expulsion of an activist, Dalkun Issa, from the UN premises in Geneva.
Wait, a top UN official kicked out a human rights activist?
Yes. And his justification was even more shocking. He said he did it because he was representing China's interests.
But he's a UN official. He takes an oath of neutrality. You're supposed to leave your nationality at the door.
Exactly. He openly violated that oath. He even mocked the Assistant Secretary General for Human Rights, essentially saying his own rank was higher, so he didn't have to listen to him regarding human rights concerns. It shows this brazen disregard for the independence and integrity of the entire UN system.
It really feels like the system is being eaten from the inside out. You have states engaging in lawfare on the outside, and you have officials on the inside acting as agents for their home countries.
That is a very apt description. But here's the thing. Arresting people like Frenchie Mae Cumpio is messy. It looks bad in the international press. Threatening UN experts generates terrible headlines.
Right, it's noisy. It draws attention.
So smart authoritarian regimes are evolving their tactics. Instead of just silencing the critics, they are now trying to replace them. They want to fill the silence with their own noise. And this brings us to Section 4, the tactics of silence.
What does that look like in practice?
It looks like a juango.
A gungo. That sounds like a drum or something.
Chuckles. It stands for Government-Organized Non-Governmental Organization.
That's a complete contradiction in terms. An NGO is supposed to be non-governmental by definition.
It's a dangerous contradiction. These are groups that are set up, funded, and controlled by the state, but they show up in Geneva pretending to be independent civil society. They get accredited, they get passes, and they crowd out the real NGOs.
So instead of a genuine human rights activist getting the microphone to say, my government is hurting people, you get a gongo representative saying, everything is wonderful back home, the government is great, and those critics are all liars.
Or worse, they use their speaking time to attack the real activists by name. The source material highlights a very visual example of this. China set up a huge exhibit at the Palais des Nations in Geneva. It was called Home, Glimpses of Life in Xinjiang.
In Xinjiang, where the widespread persecution of the Uyghur people is happening.
Precisely. And this exhibit was co-sponsored by a known gongo. It presented this totally sanitized, happy version of life there. Pictures of people dancing, smiling faces, all designed to counter the credible reports of abuse and forced labor camps.
It takes up physical space and narrative space right inside the UN.
It does. If you're a diplomat walking down the hall, you see the propaganda, not the reality. It's gaslighting on a global scale.
And then there are the smear campaigns. This isn't just about drowning out the truth. It's about actively destroying the credibility of the messenger. The sources spend some time on the case of Adamir in the Israel-Palestine context.
Yes, Adamir is a Palestinian prisoner support association. In October of 2021, Israel officially designated them as a terrorist organization.
The T word, again, it's the exact same tactic we saw with Frenchie Mae Cumpio.
Exactly. It's a recurring pattern. You don't debate the lawyer or the reporter, you just label them a terrorist. In Adamir's case, the report also highlights the role of another group called NGO Monitor. This group meticulously tracks Adamir's activity at the UN and publishes reports labeling it anti-Semitic or terror-linked.
And this has real-world consequences. It's not just name-calling on the internet.
Oh, massive consequences. It dries up their funding. European donors get scared. They don't want to be accused by these watchdog groups of funding terror. Diplomatic support waivers. And then, on the ground, the staff get arrested. The report mentions Salah Hamouri, a lawyer for Adamir, who was eventually deported. Their offices were raided. It effectively dismantles the organization's ability to function and to speak to the UN.
And just to show that this isn't about one side or one conflict, the report also brings up a case from Yemen, Watana, for human rights.
Watana is a fascinating and tragic case because they are attacked by everyone.
Literally everyone involved in the conflict.
Yes. The Houthis, or Ansar Allah, they threaten them with grenades and detention. The internationally recognized government harasses their staff. The Southern Transitional Council detains them. They get it from all sides.
And why?
Because Watana documents abuses committed by all sides, impartially. And that proves a fundamental point of this deep dive. Reprisals are a tool of power. Any power structure, whether it's a rebel group, a recognized government, or an occupying force, will use reprisals to avoid accountability. They all hate having that mirror held up to them.
This brings us to Section 5, and this is arguably the most disturbing part of the deep dive. It's about the damage we can't see. The sources refer to it as the iceberg theory.
Right. The Assistant Secretary General for Human Rights admits this herself. The cases we know about Frenchie Mae Cumpio, Anexa Alfred Cunningham, the staff at Adamir, they're just the tip of the iceberg. The real goal of reprisals isn't just to punish one person.
It's self-censorship.
It is. The real goal is to make everyone else too afraid to speak.
It's the logic of making an example out of someone. You punish one to silence 1,000.
Exactly. If you're a young activist in Tacloban and you see Frenchie Mae Cumpio, a journalist your age, get 18 years in prison for financing terrorism, are you going to write that next article about military abuses? Probably not.
If you are an indigenous lawyer from Nicaragua and you see a UN expert banned from her own country, are you going to agree to serve on a UN committee? Maybe not. You have a family to protect.
And this creates what the report calls blind spots or black holes in the international system. The sources use Bahrain as a key example here.
Right, I remember this. Bahrain was missing from some of the recent UN reprisal reports, and at first glance you might think, oh, that's great. No reprisals in Bahrain. They must be doing a great job.
But the reality, according to ISHR, is that civil society there has been so effectively crushed, so many people are in prison or in exile, that there is literally no one left to even report a reprisal.
The silence doesn't mean safety.
The silence means total suppression.
That is genuinely chilling. It's like trying to measure the darkness. How do you measure the reports that were never written? The calls to the UN that were never made?
It's a huge methodological challenge. The ISHR report suggests trying to track attempts to corroborate, or using proxy data like civic space ratings. But it is very, very difficult. At the end of the day, the UN system relies entirely on voluntary cooperation. If people are too scared to volunteer information, the system goes blind.
So let's try and bring all of this together. We started in a single courtroom in Tacloban with a 27-year-old journalist, and we've ended up traversing the entire global machinery of human rights.
And we've seen a clear pattern. From the Tacloban 5 to the halls of Geneva, the system is under incredible strain. The mechanisms exist. We have the resolutions, we have the senior officials, but the states that want to avoid accountability are adapting faster.
They're using lawfare. They're not just disappearing people in the middle of the night as much. They're passing sophisticated laws about terrorism financing and foreign agents and using their own courts to do the dirty work for them.
And they are using gungos to muddy the waters and hijack the narrative. And most brazenly, they are attacking the UN experts directly. It is a sophisticated, multi-front war on truth and accountability.
And the human cost is so real. We can't forget Frenchie Mae Cumpio. Today, as we record this, she is spending her 27th birthday knowing she might not be a free woman until she is in her 40s.
And Mariel Demakil alongside her. And the families in Yemen who just want the truth, and the exiled Nicaraguans who can't go home, these are the people the UN depends on.
That's the central paradox, isn't it? The UN needs these people to be its eyes and ears on the ground, but the UN often cannot protect them when they choose to speak.
It raises a very provocative and frankly uncomfortable final question for you, for our listeners. We often think of the UN as this powerful global arbiter, but we have to ask, if the safe channel to the UN, the very act of reporting a violation, becomes a trap that leads to prison or exile.
And if the UN's own experts themselves are being threatened and banned from their home countries. Are we witnessing the effective dismantling of the international human rights monitoring system from the inside out?
And it leads to a tougher question. If the UN cannot protect those who talk to it, who is actually left to listen, is the risk worth the reward?
That is a heavy thought to end on. But it's the reality of the sources we have in front of us today. To our listener, thank you for joining us on this deep dive. I know it wasn't an easy one, but it's one we felt we needed to take.
Absolutely, because awareness is the first step against silence.
We'll see you on the next deep dive. Stay curious and stay safe.
Welcome to the debate. 18 years. That is the number ringing in the ears of journalists and human rights defenders across Southeast Asia this morning. It's Thursday, January 22nd, 2026, and in a landmark and frankly chilling decision, a Philippine court in Tacloban has convicted journalist Frenchie Mae Cumpio and activist Mariel Domaquil of terrorism financing.
It's a huge verdict, there's just no downplaying that. We're talking about the first ever conviction of a journalist under the Republic Act 10168. That's the Terrorism Financing Prevention and Suppression Act. And, while the headlines are understandably focusing on the journalist label, the court itself seemed to focus entirely on the money trail.
And that distinction is exactly what we need to unpack today. This verdict isn't just about one reporter in Tacloban. It represents a collision, really, between national security laws and the international mandate to protect human rights defenders. We're looking at a textbook example of what the United Nations calls a reprisal, punishing someone for engaging with human rights mechanisms.
Or, conversely, it's a case of a sovereign nation enforcing its laws against funding an armed insurgency, regardless of the defendant's day job. Today, we're debating whether the UN's complex architecture, specifically the work of the senior official on reprisals and the mechanisms established under Resolution 3621, is actually a shield for activists, or if it's a hollow promise that endangers the very people it claims to protect.
I'm taking the position that the UN system, despite its, bureaucratic pace, is the only real barrier we have against what's being called lawfare, the weaponization of the law itself to silence dissent. The Cumpio verdict is a terrifying example of why we need to strengthen things like the interactive dialogue and the reporting lines to the senior official.
And I'll be arguing that the UN is overreaching, that by conflating criminal prosecution with persecution and, by offering protection it has no actual power to enforce, the UN is creating a dangerous moral hazard. It encourages confrontation with the state, but then it vanishes when the prison door is actually slammed shut.
Okay, so let's start with the immediate shock of this verdict. Just to set the stage, Frenchie Mae Cumpio has been in detention since 2020. She was only 21 when she was arrested. Now, at 27, she is looking at a sentence that could keep her behind bars until she's nearly 40. The UN Special Rapporteur on Freedom of Expression, Irene Khan, explicitly warned that this case bore all the marks of a reprisal.
Right, but let's look at the why behind the verdict before we jump to the international condemnation. Judge Georgina Perez of Branch 45 didn't just pull this sentence out of thin air. The conviction relies on the discovery of roughly 557,000 pesos, that's about 10,000 US dollars, and ammunition during a raid. The court found that this money was destined for the New People's Army, or NPA. Now, the NPA is a designated terrorist organization in the Philippines. So, if we strip away the emotion for a second, isn't it the state's primary duty to stop funding for armed groups that attack its own soldiers?
That whole frame assumes the evidence is legitimate, though, and that is a huge assumption in the context of the Philippines. You have to understand this concept of red tagging. For listeners who aren't familiar, red tagging is a phenomenon in the Philippines where individuals are publicly labeled as communists or terrorists by state agents, often with no proof, which effectively paints a target on their backs. Cumpio was red tagged specifically because of her reporting on military abuses for the Eastern Vista. The evidence you cite came after she was already marked as an enemy of the state.
But red tagging is a political term. It's not a legal defense. And the court actually showed some discernment here. Remember, they acquitted Cumpio and Domaquil on the illegal possession of firearms charge. If this were just some kangaroo court designed to silence a critic, why acquit on anything? Why not just throw the book at them on every single count? To me, the acquittal suggests the judge looked at the evidence, found the gun charges weak or unsubstantiated, but found the financial evidence compelling.
I see the acquittal on firearms as a strategic move to create the illusion of fairness. It creates this veneer of judicial independence that makes the financing conviction harder to attack internationally. But let's look closer at the financial charge. The defense gave a clear alternative explanation. That money was for the Stand with Summer Late campaign. It was humanitarian aid for farmers. By convicting on this, the court is essentially saying that any humanitarian work in conflict zones is indistinguishable from terrorism financing. And that is the lawfare I mentioned. It creates a legal environment where you simply cannot help a marginalized community without risking 18 years in prison.
That's a bit of a slippery slope argument, though, isn't it? Humanitarian aid is legal. Funneling cash to an armed insurgent group is not. The prosecution's argument, which the court clearly accepted, is that the humanitarian label was a front. And we have to respect that a domestic court is, I think, better positioned to weigh witness credibility than a UN rapporteur sitting in Geneva. This is where the tension is. The UN assumes that because Cumpio is a journalist, the charge must be trumped up. But journalists can commit crimes too. Just because you hold a press pass doesn't mean you can't also violate the Terrorism Financing Prevention and Suppression Act.
They can, of course. But the context here just screams persecution. And this is where the legal inconsistency becomes so glaring. Just a few months ago, in October 2025, the Court of Appeals, a higher court, reversed the civil forfeiture of Cumpio's assets. They explicitly rebuked the Anti-Money Laundering Council for hasty labeling, essentially saying there was no evidence linking her to the NPA. So you have a higher court saying no link in a civil case, and then a lower court saying guilty beyond reasonable doubt in a criminal one. That isn't just messy. It suggests that the criminal court was under pressure to deliver a conviction to justify the 5 years she already spent in jail.
It is messy, I'll grant you that. But, lawyers know that civil forfeiture and criminal trials have different scopes, different standards of proof. The civil case was about the assets themselves. The criminal case tackles the intent and the network. And frankly, that Court of Appeals ruling might have pressured the lower court in the opposite direction to reassert its independence. The Police Regional Office 8 released a statement effectively saying, "See, the judiciary's working." They view this as a win for the rule of law, proving that international pressure, like Irene Khan visiting Cumpio in jail, doesn't dictate Philippine court rulings.
But that independence looks a lot like defiance of international norms. And this brings us right to the core of the UN issue. This case is exactly what the UN defines as a reprisal. We should get specific here. The Office of the High Commissioner for Human Rights defines this very clearly. Acts of intimidation against those who cooperate with the UN. Cumpio's reporting was feeding into the monitoring mechanisms that the UN relies on. If you cut off the source, the journalist, you blind the international community.
Okay, let's talk about that mechanism. The UN has built this massive architecture to deal with reprisals. We hear these terms thrown around, but what are they? You have the senior official on reprisals, which is usually the Assistant Secretary General. Their job is to specifically track these instances where people are punished for talking to the UN. Then you have UN Rights Council Resolution 3621.
Which is a crucial resolution.
It is. On paper, Resolution 3621 mandates the Human Rights Council to discuss these cases. It established the framework for what they call the interactive dialogue. But what's the actual output? We have reports, we have people talking in a room in Geneva. But today, Frenchie Mae Cumpio is going to prison. So the mechanism failed. The machinery of Resolution 3621 did not stop the machinery of the Tacloban Regional Trial Court.
It didn't fail. It's being tested. You're looking at it as a transactional exchange. UN speaks, prisoner goes free. That's just not how international law works. Without the senior official tracking these cases, Cumpio would be an anonymous prisoner. The international dialogue, which for our listeners is essentially a formal session where states are publicly questioned about their human rights records, is the only forum where the Philippines has to answer for this. It imposes a diplomatic cost. We see this with the Tacloban 5, the group Cumpio belongs to. The international spotlight likely prevented extrajudicial measures, which, let's be honest, happen all too frequently in the region.
It could have been worse is a tough sell for someone facing an 18-year sentence. And I worry the chilling effect is going the other way. The International Service for Human Rights, the ISHR, they released a report highlighting a trend of self-censorship. Victims are realizing that talking to the UN is dangerous. The UN offers a platform. Come, tell us your story. But it doesn't offer a shield. It can't stop the police from knocking on your door the next day. The interactive dialogue is becoming a place where brave people go to ruin their lives.
Well, that's a cynical view that completely absolves the perpetrators. The UN isn't the police force, it's a normative body. It sets the standard. The very fact that self-censorship is happening proves that states are afraid of this information getting out. And look at the scope. It's not just the Philippines. We see it in Egypt with activists from COP27. We see it in China. We see it in the targeting of families like Issa Traoré in France or relatives of activists in Cameroon. The state strategy is clear. If we can't silence the activist, we crush their support network. The senior official on Reprisals is the only entity connecting these dots globally.
But are they connecting the dots or just counting them? The ISHR noted that some countries, like Bahrain, were dropped from recent reports, not because things improved, but because the intimidation was so successful that no one dared to speak to the UN anymore. The silence was interpreted as progress, or at least a lack of data. That is a systemic failure. The senior official often relies on private representations, quiet diplomatic phone calls. Clearly, those phone calls didn't work for Cumpio.
The system is evolving, though. We are seeing a shift because the states themselves have escalated. It's not just activists anymore. States are now attacking the UN experts, the mandate holders. Look at Annexa Alfred Cunningham. She is a UN mandate holder, an expert on the rights of indigenous peoples. Nicaragua barred her from re-entering her own country after she attended a UN session. That is an attack on the UN itself.
That is a significant escalation, I'll grant you. When a state shuts the door on a UN expert, they are sending a very clear message.
Exactly. We see special rapporteurs receiving death threats. We see smear campaigns. There's a new strategic initiative by the UN Special Procedures, that's the body of independent experts, to standardize how they document these attacks. This isn't just bureaucracy. Standardization means that every threat, every denied visa, every smear is recorded in a uniform database. It builds an irrefutable history of non-cooperation. It prevents states from hiding behind administrative errors.
Or it creates a very orderly spreadsheet of the UN's own irrelevance. I'm sorry to be so blunt, but standardizing the paperwork doesn't change the power dynamic on the ground. And this brings up the whole issue of who gets to speak at the UN in the first place. We need to talk about GNGOs.
Yes, government-organized NGOs. This is the other side of the reprisal coin.
The acronym itself sounds contradictory, doesn't it? A non-governmental organization that's organized by the government? Now, you would argue these are fake. I would argue they represent a segment of civil society that happens to agree with the state.
No, I have to push back hard on that. A Gongo isn't just a group that agrees with the government. It is an entity created and funded by the state specifically to drown out independent voices. Take the China Society for Human Rights Studies, or in the Israel-Palestine context, groups like NGO Monitor that aggressively attack Palestinian human rights organizations. Their purpose in the interactive dialogue is to heckle, to filibuster, and to confuse the record. They clog up the speaking time so that genuine victims of reprisals, people like Cumpio's colleagues, can't even be heard.
But who decides which NGO is independent and which is a gongo? If a group of citizens in Samar supports the military's efforts against the NPA because they're tired of the insurgency and they go to Geneva to say that, are they a gongo? Or are they just a voice the UN doesn't particularly want to hear? The UN tends to create this binary where real civil society must be anti-government. That alienates member states and makes them feel like the whole interactive dialogue is rigged against them.
It's not about being anti-government, it's about autonomy. The ISHR has documented how these gongos physically film independent activists in the UN halls, harass them online, and create an environment of fear inside the United Nations headquarters. That is an extension of the state's reprisal apparatus into supposedly neutral ground. If the senior official on reprisals doesn't call that out, the interactive dialogue becomes a farce. It just becomes a theater of propaganda.
I would argue it's already theater. You have Western states reading prepared statements scolding the global South. You have the accused states denying everything. And then you have the activists back home paying the price. You mentioned standardization of reporting earlier. To me, that sounds like bureaucratic shuffling on the Titanic. It doesn't change the hard reality of sovereignty. The Philippines decided the NPA is a threat, they decided Cumpio funded them, and no amount of standardized forms in Geneva changed the outcome in Tacloban.
Bureaucratic shuffling is how international law is built brick by brick. Standardization matters because it creates a consistent historical record. When regimes change, and they often do, those records become the basis for transitional justice. The conviction of Frenchie Mae Cumpio today is a tragedy, yes, but the fact that it's being recorded, analyzed, and condemned by a standardized UN process means the Philippine government can't hide it. They can't just claim it was a routine criminal case. We know it was a reprisal because the mechanism exists to identify it as such.
But what's the cost of that identification? You said visibility is protection. I'm arguing that visibility can be a trap. By elevating Cumpio to a symbol of UN cooperation, she became a prize for the state. They needed to prove that the UN can't boss them around. The Philippines has a very strong streak of asserting sovereignty against what it sees as, colonial or international interference.
So the alternative is what? Silence? If Cumpio hadn't engaged with the UN, do you really think she would be safe? She was red-tagged for her local reporting long before the UN got involved. The state targets dissenters regardless of who they talk to. The UN adds a layer of cost to that targeting. It raises the price of repression.
But maybe we need to be honest about the currency of that cost. The diplomatic cost you're talking about didn't stop a judge from handing down an 18-year sentence and a 500,000 peso fine. That is a crushing blow. The mechanisms we're debating, Resolution 3621, the San Jose Guidelines, are well-intentioned soft law. But when a state invokes national security, soft law evaporates. The court ruling explicitly cited Proclamation number 374 designating the NPA as terrorists. Once that domestic legal lock clicks shut, the UN doesn't have a key.
It doesn't have a key today, but it delegitimizes the lock. That's the long game. We are building a global consensus that national security can't be a blank check for silencing journalists. The Tacloban 5 case mirrors the Viasna members in Belarus or activists in Venezuela. It is a script, and the UN's job through the senior official and the interactive dialogue is to read that script back to the world so we all recognize it. If we stop doing that, we accept that state power is absolute.
Recognizing the script is intellectually satisfying, but it doesn't get you out of prison.
It mobilizes the pressure that eventually can.
Or gives activists a false sense of security that leads them straight into the lion's den. It's an ethical dilemma the UN hasn't really solved yet.
I think we're reaching the crux of the disagreement here.
Indeed.
To wrap up my position, the conviction of Frenchie Mae Cumpio and Marielle Domaquil is a dark milestone. It's a clear warning shot to anyone engaging with the international community, but this just underscores the urgent need to strengthen, not abandon, the UN's reprisal mechanisms. Without the senior official and the interactive dialogue, the silence would be absolute. We can't let sovereignty become a shield for human rights abuses. The international scrutiny is the only leverage remaining for defenders facing these long prison terms. We must stand with them and ensure the UN mechanisms are robust enough to make the state regret this course of action.
And my conclusion is that while that sentiment is noble, the outcome speaks for itself. The 18-year sentence proves the absolute limitations of the UN system when it collides with a state's determined application of its domestic security laws. We have to be honest about these limitations. If the interactive dialogue cannot alter the reality on the ground in Tacloban, it risks becoming a theater that obscures a worsening reality. We shouldn't encourage activists to rely on a shield that at the end of the day is made of paper. The Cumpio case is a tragedy, but it's also a reality check for the entire international community.
It is a sobering day for human rights and for journalism. The debate between sovereignty and international oversight will certainly continue. But for now, the reality is 2 young women facing a very long time behind bars.
On that, we can agree. It serves as a stark reminder of the raw power of the state and the fragility of international protections.
Thank you for listening to the debate.